How are you, Ruth?
I'm fine, thank you.
You can hear me, yeah?
Yes, I can.
Okay, so we are going to continue. The others are going to join us. We continue. So there is a question you asked me on conversion of long-term leases to sectional units.
Yes.
So of course, long-term leases are these leases which are usually 21 years and more. And these leases can be converted into the sectional properties. And the process is as follows. Uh, the person makes up an application in a prescribed form and attach the following documents to the land registry. Sectional plan, original title, the long-term lease, and upon the submission of the document, the sectional plan will be registered, and the previous register closed. A new register will be opened with respect to each unit in the register sectional plan, and a certificate of lease issued.
And under what? Okay, the new register opened in respect to each sectional plan, each unit.
A register will be opened with respect to each unit in the register sectional plan, and a certificate of lease issued. You are not supposed to pay the stamp duty upon the conversion, because the requisite stamp duty was paid when registering the long-term lease.
Okay.
That is it. I think these are what I would say about this is that the conversion of long-term the conversion of long-term lease to sectional unit has not been tested of late, and it's a good thing that you brought that question, because in our after we finish, maybe in our conveyancing class, the other one which we are going to do as we near the exams, are going to do. Most likely, I'm going to go through. We are going to do non-tested areas, areas that have not been tested recently. Just predicting what may come, because if you look at the trend in CRE exams, especially now we're focusing on conveyancing, you realize that each and every exams, they bring up at least one or two areas that have not been tested before. Like in this exam of October 2022, they tested off-site plans, which we discussed in the morning, which are never come. And in the March 2023 paper, which you are going to discuss also, you'll find that there are other areas that have never been tested before. So it's good also. The Q&A, the past Q&A, help you to revise on. Let me take this one kindly. Hello? Wacha nikufungulie. Sorry for that. I've been left alone in the house, and I should have that person ought to have attended him. So welcome, Marianne. You can hear me? Marianne.
Yes, thank you. Sorry. Yes, thank you. I can hear you well.
Sasa, karibu. So there is a question you had talked about amalgamation of land. We are talking about subdivision in the morning, but also you can amalgamate, putting two plots together. And the process is just almost the same as we had talked in the morning. So let us not dwell so much on that. But this amalgamation is an area that have not been tested recently, so look out for that. That's another new area that can be tested. If you see a question whereby you are being told that someone want to put different plots plots together, and kando, and he wants to make them one big land, one big land. So you know that you are being tested on amalgamation, eh? And the process is just almost the same. Individuals wishing to combine or amalgamate parcels of land in Kenya may make amalgamation land application to the Ministry of Land in their respective county offices. You got to start with the Ministry of Lands. You fill the form. The documents that we talked in the morning. The registrar will then advise you the amounts of fees to be paid. Then the county registrar will involve the relevant authorities. Like the director of survey, director of physical planning, that control board where applicable. Then the chief registrar will then grant the approval and issue the new land certificate. The applicant then is required to submit all the existing certificates of title. So all those certificates of title that you have from small ports, you give them back in exchange to the one being land title. So if you know the application to subdivide the land, it just the same the one like this of land amalgamation, and you just twist a little bit here and there to switch your answer, and that is an area that has not been tested. I can assure you, after researching all these past papers from 2008 to mpaka March 2023. So that's an area that can come in the exams. So be look out on that. They will tell you that there's this someone he has so many plots. Maybe you want to put them together. There will be some clue there in the exam paper. So you just know that they are testing you on amalgamation. So the next thing is we continue where we stopped. The past paper. We continue with question number 3. We did question 1 and 2. Now we are going to go to question 3, which now I want to share the screen, and the screen is loading. So now question number 3. Andrew is in the process of purchasing a property that intends to build his dream home. He instructed you as his advocate in the transaction. Andrew is anxious to conclude the transactions and is fearful that he may misapply the money, he has to pay the property. Explain to Andrew the available ways he can consider to safeguard the purchase price before transfer and registration of property in his name. So this person called Andrew has money, and it seems that he does not trust him, hajiamini na pesa yake, anaona kama atatumia vibaya. So you are told available way he considered to safeguard the purchase price before transfer and registration of the property in his name. So you can try. Marianne, what do you think? Question 3A1.
So first of all, Andrew should get a lawyer who will hold the money in his stead. That stakeholder theory. And the lawyer has the fiduciary duty, so he will safeguard the money. And since he's also not allowed to mess with the money, he will hold it in a separate client's account that could actually be an interest earning account, so he could make a bit of money. Also, Andrew should send the money to the advocate using like an RTGS system, so that there's a record that he transferred the money to the lawyer in case of anything.
Yes, that question you have answered it. Do you think that the way you have answered is enough to give you 3 marks?
Maybe like 2 marks.
Yes. So the only bit that is missing from that answer is that to gain you 3 marks is that you must be able to explain the stakeholder. This question is testing more on the stakeholder. What is stakeholder? You explain it very clearly. Yes. And then this the stakeholder thing is found in LSK condition for sale, condition 5. And LSK condition for sale 2015, it is another very important document you must internalize, because in every given exam you must I can say two questions you find where someone you must be asked at least 2 questions where you are supposed to know about LSK conditions for sale, apportioning, outgoings, all those things. Notice to complete. These are documents you must internalize. Very, very important. You may not be able to quote the exact condition. Don't try to quote the wrong condition, but you can say LSK conditions for sale 2015. That one I think you can remember. You say that the LSK condition for sale stipulates that the purchase price can be held as a stakeholder held by the voters advocate as stakeholder, if it is demanded by any party, can be put in interest earning account. And the principal accrued may be dealt with the manner set out in the condition and the sale agreement. So this is another very important bit on stakeholder, which Marianne, you have not said. When the transaction does not proceed to completion, through no fault of the purchaser, the deposit with which accrued interest but less any applicable withholding cost will revert back to the purchaser. Then, if the stakeholder money is breaches, if it is because of the breach of the purchaser breaches any term of the contract sale agreement, is forfeited to the vendor, or the ultimate goal is it to have the release to the vendor upon as the transaction continues. So stakeholder is just like a trust money that is put there in interest earning account between the both advocates. If the ultimate goal is to proceed to be given to the vendor as the transaction continues according to the sale agreement, and if the sale agreement does not proceed because of no breach, if the purchaser has not done anything wrong, it goes back to him. Then if the purchaser breaches a term of the contract and the contract does not proceed to completion because of his breach, it is forfeited to the vendor. So anytime you are being asked you are being asked about stakeholder, you must say what I've said on purchasers and the vendors side, and you are going to earn your 3 marks. So we continue the next question. Question 3A, 2.
James, if you'll allow me, I'm wondering in that question,
yes,
whether if you spoke about the possibility of sorry, my thoughts are, my question is, let's say that the vendor has this money, but they have not gotten to the time of depositing the money, because the answer is towards that the money is being held so that it will go towards payment of deposit. So what if it is in the very initial stages where maybe we are in the pre-contract stages and inquiries, and we have not even gotten to the deposit? Do we still talk about the vendor's advocate holding the money as a stakeholder, or can we speak about the escrow account that is maybe jointly held between the purchaser and the vendor's advocate? I don't know whether that is possible. I'm just thinking out loud. I'm just speaking my mind. If you could kindly guide me.
So you see, this question is asking you, it's fear that he misapply the money. Unaona? So also an escrow account, unaona? An escrow account is also a possibility. But you see, the escrow account, escrow account, I usually see that it is usually between the buyer's advocate and the seller's advocate. For example, in arbitration things, I usually see those escrow account thing. So for me, you can say escrow accounts, but when you answer it the way Marianne said that, first of all, you do RTGS to the vendor to show that you send the money to the advocate, and it went to his account. Then you talk about stakeholder. You know, this is conveyancing. You know, escrow account is not you may say that and may be an answer. I can't say that is completely wrong, but remember, this is conveyancing, and anytime you must think in terms of conveyancing. So if you talk about escrow account and you don't talk about stakeholder, you will not be able, you will fail that question. So the main thing here is stakeholder, and you explain how the stakeholder works. And if you look at the LSK condition of sales on stakeholder, it is very clear on the same. So this question was generally testing the student on stakeholder. So you may talk also of escrow accounts, but the main thing here is stakeholder, saying the stakeholder, and then you explain what is the purpose of stakeholder, what I've just explained. Are we together?
Yeah, we are together. Thank you. Yeah, if you can kindly share these LSK conditions. For some reason, the ones I'm downloading from LSK, they're not the 2015 ones. They are for Kitambo Kidogo. So if you could kindly share the 2015 one.
Yes, let me share. Let me share.
Thank you.
Let me share. I'm sharing the screen. I hope you see the issue say that you use the current law. You know, there was this LSK condition for sale of 1989. It was being used for a very long time. If you quote that one,
that one is the one that is in their website. The 1989 one is the one that is in LSK's website.
So if you quote that one, you are going to Nini.
Okay, utatutumia hii hata kwa WhatsApp tafadhali.
Nitatuma. This is the current one, and amukuambia hii maneno KSL.
No, the mwalimu mentioned. I remember our mwalimu mentioned.
Yes, this one.
Yeah.
I can tell you for sure.
Yeah.
I can tell you for sure that this is a document you must internalize for you to pass exams of conveyancing. You see, this thing talks about what happened in a sale agreement. You know, the issue they say in a sale agreement, if you have seen them in law firm, they say the things they incorporate the LSK condition for sale of 2015. So all these things, if you do, you internalize the document, you'll be very good in your when you are doing your exams. These are, I can tell you, these are must if you want to pass conveyancing. So stakeholder is here. You can see 5.2 purchase price and stakeholding. The purchase price shall be paid by RTGS. What's Nani said? And other electronic means to the vendor's advocate's grant account maintained with the bank. So You just pick the most important things. You know you cannot internalize everything. Then stakeholder, the purchase price or any part therefore including the deposit held in the voters account or cautioneer in case of auctions. So it's not only in vendors advocate. You may get a question talking about auctioneers who are selling auctions, which also is not a question that has not been tested lately. So auctions is a question that has not been tested lately. So that is another area CRE might bring. A stakeholder and if divided by any part in interest earning account, and the principal accrued interest will be dealt with the manner set out in the condition and the agreement. When the transaction does not proceed to completion through no fault of the purchaser, the deposit with accrued interest, but less any applicable withholding cost charged by the bank is paid by the purchaser or as to the purchaser's instructions. Unaona? And then you add what I said that if I think it's here. Then you add what I said about if there is breach. You know, they usually say in the if there is a breach of the contract, the sale agreement, and and it is the fault of the purchaser, he forfeits the deposit. So this is a document you must internalize. Requisition of titles, 6, you can see. Objections, rescission, pre-completion, preparing of transfer, identity of the property. So please go through this document, pick up the completion. Completion is a very, very important thing. They have asked in the past about completion and what the LSK condition of sales say. What are the purchaser's obligation during completion? And the vendor's advocate obligation. The completion documents that you are supposed to give, they are all here in the condition of sales. Stamp duty. Delay in the registration. What happens in delay in the registration? These are questions that you can be asked. Outgoing and apportionment. These are questions that usually comes very, very important. Grant of possession. If, for example, a buyer takes possession before the completion date, I think is a question that was asked, either if not in October, we are going to tackle it in March 2023. What happens? Like the buyer start to pay the rent and all those things. Representation and warranties, that has not been tested so much. So remedies in case of breach. Date completion, what happened in date completion? Notice to complete, another vendor's failure to notice to complete. Either party can use a notice, can issue another to notice to complete. And in the past, they have even asked you to draft. And we are going to do drafting of conveyancing pleadings or documents because in March 2023, they asked a question on drafting, but we are going to reach there. So the drafting has come back in conveyancing. So we can I can stop to share the Nini. And now we go back to the question where we were. And we continue with the question where we left. So, question and not being informed the vendor that and entered into occupation premises. Now, we have dealt with question 3. We go to question 3A2. You have determined that the subject property is undergoing subdivision to create individual titles. And one of them which has interested Andrew. Andrew has been informed that the vendor that he can enter into occupation of premises pending conclusion of subdivision processes upon payment of annual rent. What risk exists if he were to enter into occupation? Now, you are being told that Andrew is in the process of purchasing a property to build his home. Now, this question is telling you that the property is undergoing subdivision to create individual titles, one of which Andrew is interested. Andrew has been informed by the vendor he can enter into occupation of the premises pending conclusion of subdivision process upon payment of annual rent. What are the risks if we are to enter into occupation? Remember, he has entered into occupation of the land even before the subdivision is over, and also before the sale agreement is done and the land comes to him. So, what do you think, Ruth Muhoro? You can try.
Okay, the first thing I'm thinking about, because subdivision hasn't been done or the survey hasn't been done, you can end up occupying a property that during the survey, when you decides to divide, there'll be an issue where you have occupied.
Mm.
And then another question I would ask is this annual rent, which is this?
When his annual rent, I think he's entering there as annual rent is, I think is this annual rent is paid to the, it is a leasehold, you pay annual rent to the government. That's what I'm thinking. If leasehold, if you are given a property which is a leasehold, you pay annual rent to the government, but freehold, you don't pay anything. So this tells you that this property is a leasehold.
Okay, according to what I know about sale agreement, the one who's supposed to clear the land rent and rate is supposed to be the seller. So you'll be paying part of their portion.
Yes.
And that is something else I would say, two of them.
Yeah, that's a good trial. Marianne, what do you think?
This one I honestly don't know.
Okay. Jerry, what do you think?
I am going with what Ruth has said before. I have nothing useful to add. Yeah.
Okay. This question, Ruth have given a good trial. This question also is testing you on what I've told you, the RSK condition of sales, and the relevant RSK conditions of sale is now 10. which talks about risk of taking possession before completion. You know, generally, you are supposed to take occupation to occupy a property as the buyer after completion. That is the general thing that is you are supposed to do. But if you occupy the property before the completion date, there are risks that are involved when you are the buyer. And those risks are found in LSK conditions for sale, condition 10, and which I want now to share the screen. I told you this is a very, very important document you need to internalize, because the most of the question come here. Question, you can't escape 2 or 3 questions that are asked from here. So we go to what happens if a buyer takes possession before completion. This is it. The risk. It is condition. You can even start entitlement to possession. Possession before completion. This is condition 10.2. What happens? The LSK condition for sale talks about what happens if a purchaser or a buyer takes possession of the property before completion. 10.2.1. You can say in your exam, you don't need to say the exact condition because it may confuse you. You might just say that LSK condition for sale 2015. When the purchaser takes possession of the property before completion, other than under a lease or a tenancy entered before the agreement, the purchaser occupies the property as a licensee of the vendor at a fee of a popcorn or such other fee that as the parties may agree. And the taking of possession is not acceptance of the vendor's title or waiver of purchaser's right to make requisition or objections to the title. Then, from the date of taking possession until either completion or until the vendor takes the possession of the purchaser shall. So these are the risks. Keep the property in good state of repair and condition as it may when he took possession. So that is one of the risks. He maintains the property even if he may be told the transaction may not proceed. You know, the vendor still have a right of removing you, but you have already incurred cost of keeping the property. Property in good state of repair. Then farm the property in good and husbandry manner, pay all the any rates, rents, taxes, cost of insurance, and other outgoings in respect of the property. So you at the time you take possession, you pay all the rates, rents, taxes that is required for the property. Another risk is that you have taken the property as a licensee, so you allow the vendor to access, inspect the property from time to time. Even if the transaction is still going on, the vendor still owns the property, he can come, so you don't have exclusive access to the property. Pay interest rate on the purchase price. If the agreement becomes void or rescinded, the purchaser deliver possession of the property to the vendor. Remember, the completion have not been done. So if the agreement becomes void, you give back the property, even if you are staying there. The vendor have allowed you to occupy. So in an exam, the scenario, if you state those things, possession, you must understand what I've said. Possession before completion, still the property belongs to the vendor. The vendor, the property becomes belongs to the buyer after completion and after the transfer is done. So all these things are the risks that are there. And if you state what I've just said, you are going to earn your marks. And I think that question is answered that sufficiently when you say that. We go to the next question. Ujenzi Building Company, a new incorporated subsidiary of Bora Housing, is in the business of supply of houses through building homes for sale. There are the reasons of adopting a well-known and necessary model of fitting known as sectional titles. The company is, however, clueless on how to go about it. You have been approached by Managing Director of Ujenzi Building Company to shed more light on the journey of acquisition of sectional property. Kindly proceed. Remember, this is what I said in the morning. Conveyancing tests you on the processes. And this is a straightforward question. You don't need to think. It is asking you on the process of acquiring a sectional property, which you need to internalize. And when you're answering, you give 5 points. You number them, and you are going to earn marks, your marks. So, Marianne, can you make a trial?
Okay, I think I would go about it as the procedure for like a transfer, but just highlight the specific things in sectional property. So for instance, the main stages are the pre-contract stage, where we do the due diligence, inclusive of searches and including of searches and what pre-contract inquiries. Then we go to the contractual stage, where what happens? Where we also carry out requisitions and investigation of the title, and my advocate as the purchaser will draft the sale agreement, and then we go after contract stage, we go to completion stage, where the vendors advocate drafts the transfer, and we meet at the vendor's advocate's office for venue. Time is either stipulated in the contract or...
Sorry. Yes. This question is asking you acquisition of a sectional title. It is very straightforward.
I thought we would just do it like a normal sale agreement with transfer, but you just specify like things like, I am not sure. I'm not sure.
Ruth Mohoro.
For this one, sectional property, I know the one who is important is, I think here is where the surveyor is important. And also there's something about sectional, the sectional plan. Somewhere in the, I think, Landa. Let me remember how the procedure is. So, because what you want to do is to change again, the way I'd explained the one for off plan, I'd mix them up, where you want to change the mother title to individual units. So what I know is this. You'll have to get a surveyor to survey the property. You also to survey the property so that you can have georeference. And then there's some things about a sectional plan that has to be approved. Then you'll have to go to the land registry, something to approve the plan. And so that you can show the units. Then there's something about incorporating a management company so that each person can get the units. So when you're selling the sectional property, there's usually an amount you normally the people normally pay, like a booking fee. So when you do that, now you'll have to have who are the buyers, the sectional plan, the georeference. Then you go and now to the land registry and see if they can close the mother title, open the individual unit titles, registries. Yes, the flow might not be correct, but those are the things I can remember.
Yeah. That answer is correct. The only thing you need to...
I have a question.
Yes.
In this question, who are we? I thought we were buying, or are we creating?
You know, the question is asking you, you have been approached by managing director of Jersey Building to shed some light on journey of acquisition of a sectional title. Unaona? So the question is just asking you how a sectional title is created. It does not matter who is acquiring and who is getting. It is asking you to give the procedure because they don't know how a sectional title is created. Are you getting?
Thank you. I had misunderstood. I thought we were acquiring like sectional property. We are a buyer, not the ones like preparing so that we sell. Sorry, I had misinterpreted the question.
Yes. So Ujazi company they want to know more about sectional title because they don't know what it is. So you just explain what sectional title is and how it is created. And Ruth Mohoro have just stated the thing. This is the new question. This is a new question. This is the first time this question was being tested under the Sectional Properties Act of 2020. So you can see since 2021, they did not test the sectional title. 2022, April, they did not test. October is when they tested now. The other previous years from 2019, they were testing under the sectional Act of, I think it is 1987. So the process is as follows, step by step if you are writing. The first step is that the land, the mother parcel, must be properly georeferenced and approved by the Surveyor Department of Kenya. Then, secondly, that one is 1 point. Secondly, a sectional plan describing 2 or more units is prepared by surveyor from a building plan approved by the county government.
Please repeat that.
A sectional property describing 2 or more units is prepared by a surveyor from a building plan approved by the county government. Now, the other details there which are not very, very important. Remember, this is a question of 5 marks. You don't write a lot. Those documents, the application for registration of sectional plan is lodged at the land registry for registration. And from your class, I think sectional properties application is done only in Nairobi. Am I correct? Or you can do at your Nini, at your these other land registries. I think it's only done in Nairobi headquarters. Still on that point, the RM, the register index map will be amended upon registration. So still on that point, you can say that the application to register a sectional plan is compounded by an application to incorporate a management corporation or company.
Please repeat that.
Still on the application to register a sectional plan is accompanied by application to incorporate a management corporation or company, what Ruth said. You can, when you are talking about sectional property, if you omit talking about management company, you would have done yourself a very big disservice. You can omit talking, when you're talking about sectional property, you must talk about sectional plan, you must talk about management company, being prepared. Those are very, very important documents. Once the sectional plan is registered, the land registrar is required to submit the registrar plan to the county government for apportionment of rates within 21 days. Once the sectional property is registered, the land registrar is required to submit the registrar plan to county government for apportionment of rates within 21 days. A very, very important step now, which you can't omit this one when you are talking about sectional process of creating a sectional title. The register relating to the mother title is closed, and the title is surrendered to the large registry. A separate register is open for every sectional unit. So I will repeat that. The register related to the mother title is closed and the title is surrendered to the land registry. A separate register is open for every sectional unit. Finally, last but not least, then certificate of title. That is when this subdivided mother title was a freehold land, or certificate of lease, if the mother title was a leasehold, are issued to each sectional unit at a fee. Certificate of title for freehold or certificate of lease, it will depend on the question, are issued and each sectional unit at a fee. I think if you say that you have earned yourself 5 marks, so sectional title, very, very important things is you must talk about georeference. You must talk about sectional plan. You must talk about management company. You must talk about mother title being closed. And you must talk about each sectional unit getting its own title deed. Those are very, very important things they look out in the exams. And you're going to earn yourself 5 marks. So in a question, how do you know that they asking this question land? They asking this question is freehold, and this question is talking about leasehold. How do you know from the question, Jerry? How can you differentiate?
Sorry, differentiate, tell whether it is a leasehold or a freehold.
Yes. In a question, in an exam, what are the clues to tell you that this question, this is a leasehold and this is a freehold?
For example, if they talk about certificate of title and certificate of lease, then I will know that one is freehold and the other one is leasehold. Certificate of lease, for example.
Mm-hmm.
And if it we are talking about conversion, if it was before the Land Registration Act, the regime under which it was registered, if it was registered under RTA or under LRA.
Mm-hmm.
Those are the two that come to my mind.
Okay, Marianne, what do you think? But in an exam, they will rarely tell you that. If I have opened a question paper, you will see. They will rarely tell you that. How do you know that this? Because you have interacted with the question papers, past papers. How do you know that this is a leasehold or leasehold?
In addition, if they are talking about payment of rent, then it's leasehold. If they are talking about rate only, then I would assume it is freehold.
Yes. Yes. Marianne, you have anything to add?
No, not really. I think she said everything. But then the only difference is if it's RTA, it's a lease. RLA is the freehold.
Okay. Sawa sawa. Ruth?
Marianne, you said RTA is a lease and the other one is?
RLA.
No, that's a freehold.
Yes.
Okay, thank you. Oh, I have nothing else to add. Thank you.
You find that in question, when they are talking about question paper, you find them talking about anytime you see that they are said at least for 99 years, they will say that in a question, 99 years. You saw that, you know that directly that is a lease. That is not a freehold. Also, you see where they talk about rent. They also talk about peppercorn, paying a peppercorn rent. So that you know that that is a leasehold. And I'm talking about that because those things usually trick students very much. Before we start answering a question on land, know whether this land is freehold, leasehold, public land, or community land. And by the way, community land, they have not tested for a very long time. And that is another area you must look at when you are prepared. I think it came last in 2016. So they may ask you about community land, which we are going to look at later. Then we go to the next question. Question 4. Karen bought a vacant land from James in 2005. Details of property are as follows. Location, Muthaiga North, LRA. What I was telling you. In fact, I had not looked at this. Rent, a peppercorn. So when you see a question that is talking about this one, a peppercorn rent, term 99 years. So that is that tells you that these are leasehold land. Acreage 0.0428 hectares. Purchase price 300,000. Upon purchase, she should proceed to erect her dream home, a 5-bedroom maisonette where she currently resides with her children. She calls you and advises that she has been seeing unknown people in the neighborhood, surveying and develop pieces of land and taking photographs of the houses nearby, including hers. She quickly initiate a search over the property, and the result indicates that the proprietor is James, the previous owner. Karen rushes to your office with a pack of documents, panicking on her next move. Upon perusal of the documents, you come across a transfer document executed by all the parties as well as the original title amongst the other document. Karen instructs you to lodge the transfer that afternoon to avoid further exposure over the property. Now, advise Karen on the registrability of the transfer document as drawn and the immediate steps that you take to protect her interest pending registration of the transfer. So, trying to explain this question before I ask you, this person, Karen bought a property in 2005, and all the details are there. And this person, it was sold by James, but they did not, and he took occupation, of course, but they did not do the transfer. But he has the transfer document by all the parties executed at those in 2005. Then he also have the original title still in James' name. So because of these people who have started taking and the search has indicated James, of course, is still the proprietor. So because of these people who have come to started taking photos in the neighborhood and his house, he wants you now to register the transfer as your advocate, as drawn, and immediate steps that you will take to protect her interests pending registration of transfer. 2 marks. Jerry, what do you think?
Now, forgive me. Now I am between the years because now this is 2005.
Yes.
Now I am wondering the effect of the Land Registration Act of 2012 and the period. So what comes to my mind, not that I have any section in mind. I'm saying that that land registration form that was drawn in 2005 is not valid, because now we will have to conform to the provisions under the Land Registration Act. But I am not very sure what section of the Land Registration Act provides for this.
Now,
yeah,
advice canon on registrability. You see, in an exam, if you are asked advice canon on the registrability of the transfer document, that is one part as drawn, and immediate steps to protect her interest pending registration. So advice Karen on registrability of the transfer document. What is your advice to Karen? Jerry, I'm still on you.
That the document as drawn in 2005 is not registrable. So we will need to conform to the provisions of the Land Registration Act. So because now this is conveyancing, then I will not advise her that the immediate next steps is to file any document. I am, please forgive me, I need to refer to the Land Registration Act to see what happens in this scenario. I'm not clear on that one at the moment.
Okay.
Yeah.
That is a good trial.
Yeah.
Yeah. If I was marking this exam, I'll give you 1 mark.
Okay.
Marianne.
I follow in what she's saying. I don't think it's transferable. So I don't know if we'll have to hint at this, at the process of conversion first. And with respect to steps to protect pending registration of the transfer, I think we go to that there's a topic, we haven't learned it in class. Yeah, cautions, inhibitions, and sijui caveats.
Yes.
Something like that.
Yes. Yes, you have not learned,
Not yet.
Very good. You have introduced another thing called caution. He needs to lodge a caution to the property, to the registry as an encumbrance to the land. You have not learned, but now you have gone ahead. So that is good. You have introduced another thing called caution, because you have immediate steps. Immediate step is first of all to put a caution. Then Ruth Muhoro, what do you you can add anything else?
I have a question.
Yeah.
I have a question. Based on the argument. If the transfer forms that had been completed cannot be used now, what if the owner, that this man
James
is dead?
You want us to look for okay, you are asking me if an exam comes like that?
No, I'm just wondering. I don't know, you've not confirmed. I didn't know what is if the registability. If okay, I've heard that it can't be, you have to conform to the Now Act. But what happens if this James is not there?
Of course, you can say that the representative of the personal representative of James need to transfer the documents. Okay. But in an exam, don't assume facts.
No, just asking. There you can just think beyond.
Yes, the personal representative will need to try to because the transfer must be signed again afresh. So if James is not there, the personal representative who took the grant will sign on behalf of James. So if an exam comes that way, that's how you answer. But you remember that document I shared, doing by exams. You can fill in your facts when you're especially when you are drafting, but you don't add something new that completely changes the question. So the question is, it does not tell us that James is dead, so he's still alive. So James being still alive, they need to execute the transfer again. So this if you're writing, write the following. Regulation 48.1 of Land Registration, General Regulation 2017. You can look later. Regulation 48.1 of Land Registration, General Regulation 2017. These are very, very important document because it contains the procedure. You know, the Land Registration Act contains the procedure, and the Land Act is the main act. These are things if you want to pass conveyancing, you must read them and make your notes. You internalize, because this is where you quote the law from. And you remember what you said in the morning. They usually tell you, you cannot answer a question without quoting the law. Even if you don't know the specific law, just say Land Registration General Regulation 2017. That is enough. Said, unless the parties to a contract expressly provide the Royal Society Condition of Sales 2015 shall apply to the contract of sale of an interest of land. So, in any contract of sale of land, the conditions for sale of the Royal Society Condition for Sale 2015 applies. So anytime you are talking about land and there is selling of land, in the back of your mind, you must know that RSK Condition for Sale 2015 applies. So that's why I was insisting. Also, that is a very, very important document. So the Royal Society Condition of Sale 2015 provide 90 days for completion of sale from the date of agreement to date of receiving completion documents. So, of course, this is a sale agreement between the sale when you date of the agreement until the completion. So you are laying ground to see this sale agreement, how it violated this thing. So, of course, this completion, this agreement was made in 2005, and now we are in 2022. So, since the sale was done in 2005, and the transfer and completion did not take place within 90 days, the transfer cannot be registered. So the parties need to, the transfer need to be drawn afresh and be signed by the parties. Section 36(2) of the Land Registration Act states that an unregistered instrument can operate as a contract.
Which section is that again? Section
36(2) of Land Registration Act.
Okay.
States that an unregistered instrument can operate as a contract. That's this unregistered transfer is a contract between James and Karen. Even if you don't remember the sections, please remember that an unregistered instrument can operate as a contract if it is signed by both parties. So you may find a question in conversing asking you on that. So Karen need to register a caution. So that is the part B of the next part of the question. Karen need to register a caution against the land. And of course, a caution, you define a caution what it is. It is defined in the Land Registration Act or Land Act. It is defined there. A caution is an encumbrance against the land to effect that no action of a specified nature in relation to land in respect to which notice has been entered without first informing the person who lodged it. So a caution is an encumbrance against the land to the effect that no action specified in relation to the land in respect the notice has been entered may be taken without first informing the person. That definition is in the Land Registration Act. And if you have not studied, you are going to study in class. But you know, they say that the sun does not wait for the Nini. You know now it's time for Nini, for preparing for the exams. You must balance classes and revision. Very, very important. So you will have earned your 2 marks. So in this question, if you say that the transfer document cannot be registered because the sale was done kitambo, you earn 1 mark. Then you say that the interest, how do you protect the interest? You talk about the caution and what is a caution? A caution, and you earn your 2 marks. The other things is that as I've just added to make the answer a bit juicy. So we go to the next question. Identify the requisite completion documents that you shall require to lodge the transfer. So these people have signed the transfer again. The land was in 2005. So there, of course, there are documents, there are fresh documents they are going to get. The fresh documents that are going to be needed when you are required to lodge the transfer. This is a question is not very difficult. If you name them one question, 1 mark per document. So we can start with Marianne. What do you think?
There's the identity card, KRA pin, passport photos, original certificate of title. These are the ones I can recall.
Okay, you say that you must use the word current ID, copy of ID. Unaona? You know, people continue changing IDs. You must use that word. Then current passport photo, size photo. You know, people's faces keep changing. 2005 and 2022, those are 17 years. The face of these people have changed. That is another 1 mark. Then this is a nini. Is a leasehold. So rent clearance certificate. Which allow the transfer of leases. Another 1 mark. Then certificate of lease. Remember, this is not land, freehold. I told you, Marianne, student confused. When you're talking about the freehold, you talk about certificate of title. If you are talking, if it is leasehold, you talk about certificate of lease. So if you say certificate of title in an exam, you're going to fail that one. So be careful next when to differentiate. That is another mark. Then current PIN certificates of the parties. That's another mark. Then duly executed transfer. Remember, the question is asking, identify the completion document you require to lodge the transfer. So the transfer need to be done again, new in triplicate in favor of the purchaser. Another very, very important document, valuation of the property, or evidence of payment of stamp duty. Remember, this property, they valued and they may have paid the stamp duty at that time in 2005. The question does not talk about those things. So you must talk about stamp duty. If they had paid, they top up evidence of payment of stamp duty. Because 2005 and now, maybe the stamp duty rates have changed. So if you say that you are going to get your 4 marks, I don't think that was a very difficult question. We got to see question 4C. Karen advises you that the vendor is not willing to cooperate in completion of the transfer. He's afraid that
James, sorry, allow me to cut you short.
Yes.
I think that another important completion document that will be required in this instance is a notice of withdrawal of the caution, where a caution had been placed because registration cannot proceed where there is a caution in place. So Karen will need now to withdraw the caution and now provide that notice as part of the completion document.
Yes. Sawa sawa. That is okay. That is very in order. We go to the next question. Karen advises you that the vendor is not willing to cooperate in completing the transfer. He's afraid that Karen's delay has exposed him to the new tax obligation, since he'll be now required to pay capital gain tax. Advise both Karen and James on their respective tax obligation with respect to the transfer. Now, Karen advises you the vendor is not willing to cooperate in the transfer. He's afraid that Karen's delay has exposed him to the new tax obligation, since he will now be required to pay capital gain tax. Advise both Karen and James on their respective tax obligation with the respective transfer. If you are Nini, any question that you are told about tax obligation, And you have seen, I know you have interacted with my Q&A. They keep asking the tax obligation. What are you supposed to say? There are two things there. You must say when you are told to speak about tax obligation. There are two things you must state. So, Ruth Muhoro, what do you think this question?
Let me pass.
Okay. Jerry?
I think there are four.
Yes.
One is the stamp duty.
Yes.
The stamp duty is paid by the purchasers, by the purchaser of the property. Mm-hmm. Then we have
what is the percentage?
2%. The percentages are different depending on whether it is in a municipal area or agricultural. So I think there's 2 and 4%, but I am not very certain. You will kindly guide me on that one. Mm-hmm. Then we have the capital gains tax. The capital gains tax is paid by the vendor, and this is calculated as follows. So there is the original valuation, or the let's say this person who sold the land to Karen, how much was the initial valuation, and then you consider any improvements on the land, mm-hmm. and any costs that you have incurred, let's say the legal costs and every tax you have every expense that you have incurred to improve that land or to make it better or even to acquire it. And then the selling price. Now you will take the selling price less the expenses that you have incurred to improve that land, and then you're supposed now to pay the capital gains tax on that difference. Again, I'm not remembering the percentage of that. And then the last one, I don't know whether this one came up in one of our discussion groups. There was a question about VAT, and there was a case decision in 2018 that was saying that VAT is not payable on commercial properties, but then this decision was reversed. So the position as it is now is that 16% VAT is payable on acquisition of commercial properties. Mm. Those are the three tax implications that come to my mind. Mm. Yeah.
Okay. Miriam, do you have anything? That's very correct. I think we can.
Is the 4% is for like towns and urban areas. The 2% is for the rural areas.
Yes.
Those that are not considered municipalities. And with lieu to value-added tax, the case that established it as non-exemptable now is NBK versus KRA 2022.
Okay. So, say the last bit, Ati. NBK, this VAT percent.
Yes.
Yes. Okay. Can you repeat?
And NBK versus KRA 2022.
Okay. What does it say?
Initially, they had tried, there was a case versus KRA. I cannot remember the name of the person. I think it was James someone. In the initial, or was it Sandego? I can't remember. In the initial case, he had won against KRA, where it had been said that sale of land with commercial buildings was exempt. Mm-hmm. But then in this case, they passed it and they said that it is not exempt.
Okay.
VAT was payable.
Okay. Yes. So VAT is payable 16% on commercial buildings.
Yes.
On commercial, yeah, not only buildings, it is on commercial transactions. So whether it's a building, whether it is land that is going to be developed for commercial purposes.
Okay.
Yeah.
Yeah. To be fair, That one is something I did. I was not knowing. So that's a new knowledge I've gotten from you, and I'm going to investigate further, and I'm going to add on this question 1C. This question is question 4C, and the capital gain tax. From you know, these tax things keep changing, eh? That's why you must be kama unaona Finance Act saizi imeleta maneno ya digital tax starting this September. So someone like me who is doing online thing and people are paying online, I'm supposed to investigate digital service tax and know if I'll pay. So the capital CGT rate was another very important point is that CGT, capital gains tax, is paid whether or not the property was acquired before 1st January 2015. It was 5% last year when that exam was being done, October. But effective January 2023, it is 15%. And the CGTs is upon registration of transfer instrument in favor of the transferee. You paid after you have, it is paid by the vendor after the transfer has already been done. So on top of what Jane has said, you add the things that I've just said, and I think you are going to earn your 4 marks. So every time you ask a question on tax obligation, you must state who is supposed to pay. It is the seller or the buyer. How much? You must know the figures, and when is it payable? And this new information you have given me here on VAT, I'm going to study it, and I'm going to add there in the question. So we go to the next question, which is question 5, which will be our last question. Peter is a registered owner known as Nakuru Net 360, measuring approximately 20 acres. The national government is in the process of expanding the road network in the area and has issued a notice to the landowners likely to be affected by the project of impending changes of their land ownership. Peter has approached you to act as an advocate on the issue. Is unwilling to part with any portion as the parcel consists of unsettled land. So if you are told someone have a registered owner of our parcel and the national government want to expand the road and they want to take this land of this person, what do you think, even before you read the other question, the sub A, sub B, and C, what do you think this question is likely to test you on, Marianne?
An involuntary transmission through compulsory acquisition.
Yes, very good. So every time you see where they are saying they want to expand, the government want to take your private land. So you know that the question is testing you on compulsory acquisition. Question A, explain to Peter the nature of intended action and the procedure required before your current land can be affected by the project and safeguards that exist to protect his interest. So the intended action is compulsory acquisition. That one, Marianne, you have already answered. Now, the procedure of compulsory acquisition. These are 3 marks. So you don't need to say a lot of things. Ruth, you can try.
Okay. Oh, what I know is that the national government has to put an advertisement of the intended acquisition.
Yes.
And also give a notice to the National Land Commission.
Yes.
Then the National Land Commission will call upon all the people who are interested, who might be affected by this, and listen to their case. There has to be valuation done on the property. And according to the Constitution, I don't know if it is Article 60
40.
or something. There's an article, 40, where they're supposed to be given the payment in full, full and something.
Just and
they're supposed to be given in full and expeditiously, so that there can be any form of corruption. Yes, I think that is what I know.
Yes, that process is okay. The only thing you need to add there, you says that a very, very important process you need to add before they usually gazette, the National Land Commission usually gazette the parcels of land that they need to acquire, they need to acquire. Then you also need to say that they must hear the representation of of course, that you have said, they hear the people who are affected, and after they agree on the payment, the National Lands Commission pays, and that question is you answer. You have gotten your 3 marks. That's not a very difficult question. You just need to tweak in 1, 2. These are just 3 marks, and I think Ruth, you have answered it well. Advise your client on the possible avenues that he may utilize to ensure that the land is not affected. Advise your client on the possible avenues that he can utilize to ensure that his land is not affected. So, Jerry, what do you think about that?
I am lost, because the question seems to indicate like there is something you can do so that the compulsory acquisition does not proceed. But then I'm thinking, if the procedure has been followed, there is nothing you can do if the government is desirous of acquiring the land. That's where I'm lost. Yeah.
Okay. Miriam, what do you think?
I'm with her. I'm not sure there's much you can do because of the alludium. What is it called? That interest of the government over all land in Kenya. So I don't think there's much you can do against it, especially if it's done procedurally correctly.
Yes, that is correct. That's how the question was supposed to be answered. You say that this Peter cannot refuse the government to take their land. So the only thing he needs to do is to participate through the process and ensure that the government, the National Land Commission pays him the money. The only dispute that has gone to court is not about refusing to your land to be taken. It's on about the just compensation. There are people who have gone to court stating that the valuation was not done well. We are not paid, and that question, that issue, in some instances they have won. So all those things you say that in your question, and you may also include a case law, which you can find online. There are so many case law. You just get one.
There is one I have. It's called, it is John Peter Mwangi Kagira versus the National Land Commission. It is started, so it has gone to 2 stages, and it is in the Kenya Law Report. So if you find time, you can.
John Peter
Mwangi Kagira versus the National Land. NLC. Yeah, so what was before the court was whether the procedure for compulsory acquisition of land was followed, because this John had claimed that there was no notice, and they had not been invited to participate in the physical meetings that are required by law. So in the judgment, the court, in that judgment, the court proceeded to see whether that process was followed, and the court's opinion was that it could only fault NLC if that process was not followed. And in the appeal case, this person was actually told to pay cost of the suit, because the court found that the NLC had followed that process to the letter.
Okay, so that's a very good case. You can, I'm going to include it in my cases. I'm going to look at it so that, remember, if you ask a question and you look at the marks that you have been given, and look if they are sufficient to answer your question. So including that case, you can, I think you get your 2 marks. Question 5C, later after receiving instruction, you find out there is a caution on your client's land. Explain to your client the nature and import of caution, the effect of caution may have on the proposed acquisition, and the steps required to remove the caution. You remember, see, this question have 5 marks. So when you're answering a question, you must answer all the sub parts. So you start by saying, what is a caution? You must explain what is a caution. And we have stated in the earlier question, we talked about caution, a caution, and as it has been defined in the Land Registration Act. Then I think that one you'll be given 1 mark. The effect of caution may have on the proposed acquisition. So what are the effects of the caution that may have on the proposed acquisition of this land? Marianne, what do you think?
Maybe the caution may prevent maybe government from taking possession of the land. I'm not sure. Until maybe the current proprietor does away with the caution.
Yes, the caution, the government cannot remember, in the process of when the government is acquiring the land, they usually do a search and to find if the person claiming the land is a person who usually is, if it is the owner. So if they find that there is a caution, the nini cannot proceed. The acquisition cannot proceed. So that person will be required to remove the caution. That is another 1 mark. So, and then the steps required to remove a caution. So, what are the steps required to remove a caution? Ruth Mohoro, you can try that one. I know maybe you have not studied in the class.
What I know, or what I think, you have to go to the land register. From there, I don't know.
Nani, Jerry, what do you think?
So what happens is that the person who placed the caution can remove. So this caution can be removed by the person who lodged the same, or it can be removed by an order of the court. And again, it can be removed by an order from the registrar. So where, for example, in this case, where this person refuses to proceed to remove a caution, and because the same has to be removed before they proceed, there are two options available to the government: the order of the court or by the order of registrar, if that person has failed to remove it after being served with a notice to do so by the registrar. This is provided for under the Land Registration Act. I don't remember what section specifically, but then it allows the registrar, if on an application by another interested person, then the registrar is required to serve notice on the cautioner, warning him that his caution will be removed at after some time, maybe after the expiration of the time the registrar will allow in the notice. And then if this person takes no action, then the registrar will proceed to remove. So the National Land Commission or the government can make that application to the registrar so that it is removed by those 3 weeks. By now, by that provision that the registrar can remove. So after the expiration of the time that the registrar has given, and the cautioner has not objected or responded or maybe acted in any way, the registrar then proceeds to remove that caution. But if the person who had placed the caution objects to the removal of the caution, then and then he notifies the registrar that he has objected to the notice that has been given to him by the registrar, then what will happen is that the registrar will give the two parties, so the person who had placed the caution and the person who had written to the registrar requesting that the caution be removed, and will invite those two parties to a hearing session. And then once the registrar hears the two sides, then the registrar can make an order as he may consider right, or depending on the case before the registrar, then the registrar will make a decision either to proceed to remove or to retain the caution in place.
That's a very good answer. The relevant question, section is section 73 of the Land Registration Act. I think this section, you can remember it for purposes of exams. See, trying the process of removing a caution. Can government be refused to? You are saying that there may be. Can the government be refused to compulsory acquire land? So the question will be removed because the government must take the land. So the relevant section is section 73 of the Land Registration Act, as Jerry has explained, and that will give you 3 marks. And this is a repeat. This question of caution usually come very much, and also inhibition and restrictions. So for purposes of exams, be knowing this, and of course you are going to learn in class. Now we have 5 minutes to go. So I am thinking we continue tomorrow. We do, or another day you are going to suggest, and you are going to ask to start with the question 6, then we go to March 2023. And because of how we are going through, I think in the morning we covered 2 questions. In the afternoon, we have covered another 3 questions. So I think we do 3 hours. We see where we are going to cover. Then from there, we are going to know how we are going to proceed next. So you can suggest 3 hours tomorrow or Monday this week, because remember next weekend we are going to deal with another subject. I want us at least to complete these exams this October 2022 and March 2023 before we look at other things I'm thinking in conveyancing, especially drafting and untested areas. So what do you think? What is your best time, Marianne? Tomorrow, Monday, 3 hours.
Tomorrow any time is fine.
Morning hours, I'm going to church. And I know also maybe you are going to church. It is in the evening hours. Ruth?
Tomorrow is fine, maybe from 3.
3 to 6. Jen,
Or 2.
2. Jen?
The afternoon works for me. From 2 onwards works for me.
Okay. So this meeting will be between 3 p.m. and 6 p.m. And I'm going to do another Zoom and share the link. Hopefully we are going to finish everything tomorrow, but of course not compromising on quality. And that's thank you for your commitment. And I can also tell you that I'm very much committed to go through this thing. I prepare a lot before I come here. And it is not about numbers, as I said in the morning. Even if it is one person, I'm going to proceed because I committed this thing. So 3 to 6 tomorrow. Anyone who can add anything, just a comment on anything.
I have enjoyed the session and I have learned new things. Thank you very much.
Sawa sawa. Okay.
I've also enjoyed the class, but I was wondering if we can have time tomorrow. I don't think so. If you can just brush through the caution, inhibition, and restriction, just in case we may or may not be taught, just in case there will be time. Okay, thank you.
No, I must. That is the first thing I'm going to do. Cautions,
okay,
cautions, inhibitions, and restrictions. I'm going to go through them tomorrow, first thing. Then before we continue, I'm here for you, Jen.
What I'm wondering in regard to that, I don't know, there's something that is usually confusing me. Are those 3 the things we refer to as the rights in alienosoro, or is rights in alienosoro, when we talk about those, are we also, caution na caveat ziko hapo ndani, ama rights in alienosoro ni inhibitions peke yake?
Aliensoro. You know, a caveat, you see, if you look at the definition in our decision act about caveats, they say caution is also include caveats. Naona. So a caveat is also another name for cautions. Then this thing called right alienoso, I'm going to address it tomorrow when I'm what Ruth have said. When you are dealing with the questions, inhibitions, and restriction, I'm going to talk about the first thing before we start our class. Sawa sawa.
Sawa, thank you.
Thank you. So, thank you very much for attending, and see you on that time. Ingia on time. You saw Jerry. You are a bit late. We are going to be starting on time, and thank you very much, and see you then.